Under students, Mr. Williams here. We're going to go ahead and get started with our next subsection in Section 6 of the American judicial system. Introduce you to the participants inside of our legal system. So the attorneys, the defendants, the prosecutors, the judge, the jury, etc. So let's talk about some of the vital roles that are filled in order to ultimately yield justice. Two terms that we first got to identify: litigants and litigation. A fancy L word here, basically describing discussion of the law or challenging of the law or an open interpretive period regarding the law. Okay? Litigants are the individuals involved in a lawsuit. Litigation is the actual process of taking legal action. Okay? So a fancy term that is immediately referenced in section 7.1 of the textbook is jurisdiction. Jurisdiction, which is literally translated into to say the law, okay? We get into another fancy term here with litigation when it comes to referring to the process of taking legal action, all right? Common terms that we use is, taking somebody to court, all right? Litigation effectively is interchangeable with that common phrase. A lawyer, commonly referred to the individual that defends or looks to prosecute somebody in a civil or criminal case. That's the common phrase. Attorney is the fancy term that we use. Or counsel, legal counsel, all right? You're providing information. Again, counsel, assistance, all right, help in the world of law for that individual, whether it's a civil or criminal case. And we'll get into civil v. criminal down the road here. The players in the legal system, all right, the litigants and the individuals that are going to be taking part in the litigation. We have the plaintiff or plaintiffs. Those are the individuals that are going to be accusing. They are making the accusations. They are looking to uphold criminal law on behalf of the people. So we're talking the county, the state, or the national government, okay? Or they're individuals that are accusing somebody else of doing great wrong to them, okay? So that's the plaintiff. The defendant, that's the individual that is being accused of committing a crime against the people, so like breaking a law, all right, a criminal act. Or it's the individual that's being accused of having broken a contract with somebody. All right, kind of like in a civil case, okay? Having done the wrong, legally speaking, to the accuser, the plaintiff. We've got the lawyers, i.e. the attorneys. They'll represent both sides. There's legal counsels on both sides of this, adversarial system here. The judge, who is going to be the arbiter, all right? The person, the mediator, if you will, the middleman or gal, who's going to be officiating, refereeing, making sure that by the processes established through our various governmental systems, both sides are being treated fairly inside the courtroom, that there is no conversation that can be seen as weighted in favor of one side or the other. So the judge is all about making sure things remain unbiased, impartial, all right, that both sides are being able to be shared with the jury, our fifth participant here, who's ultimately going to render a verdict. The jury is going to, after sitting back and observing everything from both sides, right? The defense and the plaintiffs, they're going to say ultimately yes or no to the charges or accusations that are being brought, okay? After both sides have shared all their information, after the judge has officiated this, adversarial situation, this conflict inside of the courtroom, the jury is going to sit back and say yes to the accusations that are being brought. We believe without a shadow of a doubt, all right, beyond a reasonable doubt, we believe that the defendant is guilty of the charges being brought against him. Or they're going to say, there is reasonable doubt that the defendant didn't do what they're being accused of doing, okay? So that's ultimately the task of a jury, is to kind of sit back. It's quite an obligation, all right? But it, again, is paramount in our American judicial system. Again, kind of the most envied system around the globe when it comes to, again, being able to be protected, all right, and have things done fairly. Is it perfect? Absolutely not. All right, absolutely not. There's hundreds of documentaries out there where it is not perfect, but it's about as perfect as it can get in a free democratic republic. Breaking down each one of these, which I kind of already did for you, so we'll kind of roll through this. The plaintiffs, these are the individuals that are making the accusation, all right? If the accusation is between persons, okay, somebody broke a contract with another person, most notably like divorce is the biggest one of these, okay? Then it's going to be regarded as a civil case. If the government, though, is bringing charges, if the government, state, local, national, is accusing somebody of committing a crime, breaking the law, a crime against humanity, against the people, then that's regarded as a criminal case. The second player, the defendant, that's the person, persons, or entity, so group of persons or business that's accused of the wrongdoing, okay? So the defendant, i.e. the accused, again, we want to assume that they are innocent until proven guilty. The attorneys, legal counsel, all right? These are individuals that have been trained in the profession of law. They know the law, all right? They're well-versed in it. You, the average Joe, is not, okay? So there's the prosecuting attorney. Those are the individuals that represent the accusers, whether that's an individual in a civil case or whether that's the state, the local government, or the national government, okay? So, for instance, it could be Brad Lippert, our county attorney, okay? It could be Derek Schmidt, the attorney general for the state of Kansas. Or it could be Bill Barr, the attorney general for the national government, all right? Those would be major prosecuting attorneys. Those would be like the highest prosecuting attorneys in their respective levels of government, okay? But there are prosecuting attorneys representing various levels of local, state, and national governments across the nation. The defense attorney, all right? This is the individual that you're going to get to represent you if you've been accused of civil wrongdoing or committing a crime. If you can't afford a high-dollar defense attorney, then the public will provide defense for you. This is Gideon v. Wainwright, that civil rights case from back in the 1960s, when it's stated in the Constitution that you are going to be provided legal counsel, and ultimately the taxpayer will cover your legal counsel or public defenders as good as some of the high-dollar defenders like Mr. Jose Baez, seen here with Casey Anthony and Aaron Hernandez? No, okay, most likely they're not. But they'll still do the best job, should do the best job possible to provide you with protection against potentially the unjust arbitrary power of whatever level of government is accusing you of committing a crime, okay? Casey Anthony, Aaron Hernandez, two big-time, high-profile criminal cases where effectively both defendants were absolved of their crimes, all right, not convicted, all right, not convicted of some of the heinous acts they were accused of committing. Fascinating stuff. Final players here, the judge and the jury. Mr. Lance Ito here, all right, this is the judge who, again, gained some notoriety because he oversaw the O.J. Simpson case in the mid-1990s. The judge is supposed to be an impartial arbiter, right? An umpire, a referee, and you've seen the courtroom dramas, all right? This is the individual that is supposed to make sure that neither side is stepping across the line, neither side is breaking the rules, and things remain as impartial and unbiased as possible so the fifth and final player, the jury, can render a legitimate judgment based off of the facts and the information presented by both sides. The jury is going to, the impartial jury of your peers, guaranteed to by the Sixth Amendment, is going to render a verdict, okay? And again, there are charges brought upon the accused, all right, the defendant, and the jury, after hearing all the testimony and the back and forth between each side, they've got to tell you whether or not, beyond a reasonable doubt, they believe the person committed the crime, i.e. they're guilty, or there is reasonable doubt, therefore they find the defendant not guilty of those charges, okay? So it's black and white at the end, but you got to understand there's some gray area there. The Founding Fathers were so staunchly supportive of a judicial system that favored the accused from those years and decades and generations of, again, arbitrary, ridiculous levels of power and abused authoritative positions inside of the British government. So they wanted to protect the common man, protect the common person. And they went out of their ways to develop a system that does exactly that. That's why sometimes it, from the information that's shared with you or from the surface, it looks like somebody's guilty. Like there's no way they did not commit those crimes. But they walk free. They walk free because as the jury sits there and hears the case, there's reasonable doubt that they did not commit the crimes. Therefore, they are deemed not guilty by the jury of their peers. That does it for our participants inside the legal system. We'll pick it up with the law itself, breakdown of civil v. criminal law inside our American judicial system. That's it. All right. Have a good rest of your day.